substantially different. So they are two different documents. None of the superior courts examined this fact, leading them to the erroneous conclusion that the BBI Steering Committee, the BBI Task Force, and the promoters were one and the same. Neither Junaid Mohammed or Dennis Wawere were part of the BBI Steering Committee or the BBI Task Force, both of which were gazetted by the President. Their similarly named initiative, of which their part has no legal nexus with the two gazetted entities. It is clear in correspondence between IEBC and the promoters that they engaged the IEBC as individuals and were not representing any entity, including the President. As I conclude on this issue, I fault the superior courts for making declarations of unconstitutionality without specifically itemizing the article of the Constitution that was either denied, violated, infringed, or threatened. For instance, the superior courts found the BBI process of initiating amendments to the Constitution unconstitutional. Which specific article of the Constitution it offended or threatened, it is still unclear. The superior courts ought to have dissected the issue to specific actions that were taken against the constitutional provisions against which they could be measured. Instead, it would appear that the focus was on actions, actors, and processes which are not within the constitutional ambit, and in particular, which are not to be found under Article 257 of the Constitution. In summary, my finding on the issue is the President did not initiate the amendment process in dispute. He was not the promoter of the popular initiative under 257. I now move to the third issue, which is whether the second schedule to the Constitution of Kenya bill is unconstitutional. Before ascertaining the unconstitutionality of the second schedule, it is important to interrogate the legal standing of the impugned bill. In Black's Law Dictionary, a bill is defined as a legislative proposal offered for debate before enactment. Article 109 of the Constitution says that Parliament shall exercise its legislative power through bills passed by Parliament and assented by the President. In addition, Article 116 of the Constitution talks about the coming into force of laws and speaks of the bill passed by Parliament, assented by the President, shall be published in the Kenya Gazette as an Act of Parliament within 7 days after assent. Accordingly, a bill does not become law until it is passed by the legislature, and the President completes the legislative process by formally assenting or giving his consent to the bill. Articles 2.4 and 165 of the Constitution contemplate scenarios where laws are unconstitutional and can be declared so. The Constitution does not provide for pre-enactment mechanisms to determine whether a bill is constitutional or not. So in this instant matter, the judges of the Court of Appeal did declare the second schedule of the Constitution unconstitutional, but considering that the Constitution Amendment Bill had not yet been promulgated into law, I find fault with the Superior Court's finding on the basis that they did not have jurisdiction to interrogate the constitutionality of a bill before it's been passed into law. I reiterate, it's only after a bill has been enacted and attained the status of a law that the courts acquire jurisdiction to entertain the same. But before a bill is enacted into law or an act of Parliament, the courts don't have jurisdiction to determine the same for lack of ripeness. Now, having found that there's the issue of lack of ripeness, what can this court do? Can it proceed to address the same? And if so, under what circumstances? In the case of Aramat, this court did state that this court's jurisdiction is to develop rich jurisprudence that develops and respects Kenya's history and traditions and facilitates its social and economic growth, and that the Supreme Court is the guardian of the Constitution and the final arbiter. And the same principle was stated in the matter of Speaker of Senate and several other cases of this court. In light, and I've laid out the decisions, in light of all those decisions above, it is my considered view that the issue before us is one that cannot be ignored. However, there needs to be a test to assess whether indeed, despite the lack of ripeness, whether this court can actually address the issue. So this court needs to evaluate the fitness of the issue for judicial determination, and secondly, assess the hardship to the parties and the general public if judicial relief would be denied at this stage. In other words, is this the kind of question that can be determined only when ripe without occasioning any hardship to the parties or general public? I've then laid out a number of cases and writings around the fitness test on issues of ripeness and how one can assess whether an issue is fit despite the issue of ripeness. I do find, having laid out the issues around the test, I do find that in this particular situation, that this court can apply the test and we can address the issues despite the lack of ripeness surrounding the bill. Thus, I have perused the second schedule to the Constitution of Kenya Amendment Bill and noted that it seeks to introduce an amendment to Article 89(1). However, the schedule that is attached then purports to amend Articles 81(2), 3, 4, 5, and 6, but it purports to do this on its own without an accompanying proposed amendment to that section. In the UK Court of Appeal decision, Mohan versus Her Majesty's Senior Coroner for Oxfordshire, Lady Arden observed the follows. It would be contrary to drafting conventions for a schedule to be used to make what should clearly be what has a change or what will have some change or of consequence in the law. It is improper for a schedule to have matters of principle, and nothing should be placed in a schedule to which the attention of Parliament should be particularly directed. Flowing from the above, I am persuaded that the second schedule to the Constitution Amendment Bill, even if it were to be enacted into law, cannot amend Article 89 of the Constitution. It would be contrary to drafting conventions if the schedule of the Constitution was to propose an amendment to a substantive article of the Constitution on its own. What ought to have happened is that there needed to have been a standalone provision that brought the substantive amendments to Articles 89(2), 3, 4, 5, 6, 7, and 8. Therefore, the second schedule to the Constitutional Amendment Bill conflicts with the substantive provisions of Article 89 of the Constitution, and it is therefore unconstitutional. On issue number 4, on whether the President can be sued for performing functions of his office, I will be brief. The rationale for presidential immunity comes from the enormous responsibility bestowed upon a president as a single source of executive power. Therefore, immunity from legal proceedings is designed to permit a president to just discharge his obligations with as much autonomy as possible without anxiety that court proceedings would probably disturb, humiliate, or encumber him from focusing on his duties. This protection is also envisioned to shield the dignity of the office of the president and not him personally, particularly because he makes far-reaching and sensitive decisions. I've considered the parties' pleadings and submissions, and it's obvious that the point of diversions is whether or not the president is immune from constitutional violations during his tenure of office. It is not contested that the president appointed the Building Bridges, the BBI task force, to document and recommend practical administrative reform processes that will build the country's long-lasting unity and implement modalities for each identified area. The President has a unique position in the constitutional scheme, and as already discussed in issue number 2, he has the responsibility to promote and enhance the unity of the nation. It is my finding, therefore, that if the president... No, I'm sorry. That's not where I want to go. It is my finding that the president, in appointing the BBI task force, was discharging his constitutional mandate, promoting and enhancing the unity of Kenya, and consequently, there was no basis for concluding that the president's actions contravene the constitution to deprive him of immunity provided for under Article 143 of the Constitution. There is no evidence tabled before the trial court to dispute this, and that his actions were not within the four corners of his constitutional mandate of promoting and uniting the country. One may ask what recourse is available to a party who is aggrieved by the presidential actions or omissions that grossly violates the Constitution and is outside his constitutional function. And Article 145 provides any member of the National Assembly, supported with at least 1/3 of members, the ability to move a motion of impeachment. And that is how to deal with it. To this end, I do disagree with Justice Tuyot on his conclusion that Article 132 leaves it open for the President to be held personally liable once out of office for any act or omission not done in office. And my finding is that the President's actions or omissions entitle him to immunity as provided for in under 143 of the Constitution. I'll move quickly to the next issue, which is public participation. And this is what I'll say. To determine whether the Constitution Amendment Bill 2020 was subjected to public participation within the parameters of Article 257 of the Constitution, we need to examine the steps and inbuilt mechanisms that are provided for therein. In my opinion, the steps are as follows: the submission of the bill and the minimum 1 million signature of registered voters. Then the verification of signatures by IBC. Then the consideration of county assemblies. Then the consideration of the House of Parliament, and then the referendum. So when we go to the first step, Mr. Omoke urged us that the promoters ought to have conducted public participation prior to the collection of signatures. But on this, it is my finding that the collection of signatures is not a constitutional process under Chapter 16 of the under Chapter 16, and the promoters are not under any obligation to conduct public participation prior to the collection of signatures. In order to assess whether the public participation has been conducted in accordance with the specific provision of the Constitution, the test which a court ought to apply is against a particular provision. So to my mind, Article 257 of the Constitution does not first provide for the collection of signatures, but for the submission of a bill with at least 1 million signatures. This, in my opinion, is the first step. And then second, it does not make provision for public participation during the collection of signatures. Having found that Article 257 does not expressly provide for public participation during the collection of signatures, the standard to apply when assessing the same, if any, will be lower than the law, than where the law is expressly provided for public participation. I am unable to agree with the Court of Appeal's findings that there was a constitutional requirement to conduct public civic education at the point of collection of signatures. And I cannot concur with Nambuye's finding that there was need to give the public the reports, the bill in Kiswahili, Braille, sign language before the referendum. Having found that the constitutional amendment process commences with the submission of signatures and that the Constitution is silent on pre-bill procedures, it is my right to take public participation at this juncture. From the foregoing, it is my presumption that when a supporter signs in support of the draft bill, then such a supporter must have read, understood, and agreed to the proposed as amendments, asked questions about any unclear proposal, and taken the decision to be bound by his or her signature. It therefore goes without saying that the promoter, before urging the support of his or her proposal, must talk to people or must have made his bill understood by the people. I disagree that there was no, I disagree with the court's conclusion that there was no public participation during the collection of signatures. And moving on to the next step is to consider whether there was public participation at the county assemblies. I take judicial notice that in compliance with the Constitution and the County Governments Act, county assemblies have standing orders with set guidelines on public participation, and in that regard, a bill in the county assembly, having been read for the first time, is committed to the relevant select committee, where it takes into account views and recommendations from the public and reports back to the county assembly. I've looked at the record, and it's my conclusion that none of the petitioners before the High Court specifically alleged that any of the county assemblies failed to conduct a public participation as per the standing orders. Similarly, there is a similar process before the two houses of Parliament, and there is no evidence that this public participation did not take place. It is my finding, therefore, that there was public participation at the county level and at the Houses of Parliament. The final step in assessing public participation under Article 257 is at the referendum stage, but we had not reached there. Lastly, on this question of public participation, I believe it is time for the legislature to urgently provide for the parameters of public participation. I recommend it does so through a statutory enabling framework. Such legislation should provide precision and clarity on the various processes involved and address issues like mode, extent, stages, proof of public participation, funding, responsibilities of who does what and when. Does the IBC have the requisite quorum to conduct business? It is my finding that it does. And I'm sorry. And I have then come to the two conflicting decisions in the High Court, which were raised by parties. It is my considered view that even though horizontal stare decisis is not binding on courts of equal jurisdiction, the trial courts need to follow the decision of other judges of the same court unless there are compelling reasons to depart from the same. This is to ensure consistency, certainty, predictability, and sound judicial administration. In this context, having found that paragraph 5 of the second schedule of IBC Act is constitutional, it is my finding that it was justified for the trial court in the Isaiah Biwott case to depart from the Katiba case. Furthermore, in this present case, I'm not persuaded that there existed compelling reasons to warrant the trial court in this case to depart from the Isaiah Biwott case. I have then laid out my reasoning around retrospective unconstitutionality and prospective unconstitutionality. I think that I will leave that for parties to read when they read my full judgment. Finally, on the last issue, I do agree that the issue is not ripe, like the Chief Justice has stated. However, once again, the fitness and hardship test which I developed when I was writing issue number 2, I think does apply, and I have made findings that there can only be one question at referendum, and that the provisions of Section 49 are unconstitutional. They are unconstitutional. Thank you very much.
Thank you very much, the Honorable Justice Joki Ndongo, for rendering your opinion. It is now my pleasure to invite the Honorable Mr. Justice Wanjara to deliver his opinion.
Thank you, Chief Justice and President of this court. Mine is a summarized delivery of my judgment, because I know that, or I expect counsel to read the judgment. But even if you don't read, I know that out there are Kenyans who will read it. And and contribute to the growth of jurisprudence in our country. And so I begin by also acknowledging the fact that I have perused the lead judgment by the President of the Court, and I'm in agreement with how the contents of the background have been captured and the submissions by the parties have been paraphrased. And so this enables me to immediately go into the consideration of the 7 issues that we formulated for ourselves with your concurrence. But before I do that, I must also pay my gratitude to our colleagues at the High Court and the Court of Appeal for their gallantry and industry which they invested in this enterprise. It's due to those efforts that at this stage I can say we now find ourselves in the fog of the season's end, for those of you who read beyond the legal text. And now to the first question, whether the basic structure doctrine is applicable in Kenya, and if so, to what extent. And I begin by acknowledging the fact that never since the promulgation of the Constitution of 2010 have our courts been confronted by so polemical, elastic and indeterminate notion as the so-called basic structure doctrine. And it all began with when a group of distinguished citizens, aggrieved by what they perceived was an imminent overthrow of the Constitution, approached the court, the High Court in particular, seeking its intervention to stop that overthrow. And I've also, like my colleagues, traced the origin of now what is being called the basic structure doctrine. I don't think I need to go into the stages, the historical stages of how this notion, in my view, sprouted and continues sprouting in parts of the world. I think that my colleagues who have spoken have done a sterling job, and I do not intend to retrace the history of this doctrine. But I do ask, how did we find ourselves enmeshed in this kind of theorizing? Because right from the High Court and now up to this court, what we appear to be doing when addressing this notion of the basic structure of the Constitution is really a preserve of legal and social science scholars. It is hardly an occupation of court of law, not to mention an apex court of law like this one. So how did we find ourselves in this process? It's because there can be no doubt that in approaching the court, the petitioners had been aggrieved by what they perceived as an imminent threat to the Constitution posed by this amendment bill. But instead, what they should have done, in my view, they would have laid down a prayer in which the alleged the fear of violation of the Constitution, and in support thereof, they were at liberty to deploy any arguments, propositions, and analytic tools to convince the court that indeed such a declaration was warranted. But instead, what we have here is a fundamental departure from a long-established tradition of invoking the jurisdiction of the High Court that the petitioners instead presented the court with a theoretical construct, a fait accompli, whose declaratory validation they sought. And unfortunately, the High Court elevated this proposition as designed by the petitioners into an issue for determination even at a preliminary level. And later they would be joined by our colleagues at the High Court. But be that as it may, now that the applicability of the basic structure doctrine in courts has snowballed into a ubiquitous inquiry, we at the Supreme Court may not, without stirring justified indignation, disregard it altogether. And so I have been compelled, just as my colleagues have been, to go into an exegesis of what then is the anatomy of this basic structure doctrine. I have asked myself whether indeed it is a doctrine, juristically speaking. I have come to the conclusion, after not just a soul searching, but serious thought, that what we are faced with as a basic structure doctrine is no such doctrine. Instead, it is what I consider as a school of thought, or at best, a heuristic device, which a court of law, when faced with a question as to whether a proposed constitutional amendment is of such a nature as to destroy, destabilize, or distort the constitutive authority of the Constitution, a court of law faced with such kind of question can deploy this heuristic device in its effort to answer the question. But I find no fault with this rich and diverse array of opinions, so eruditely crafted by some of our finest in the judicial system, the legal profession, academic institutions, and from far afield by way of amici curiae. Indeed, we who are called upon to adjudicate upon the affairs of men and women in their relations with one another and between them and the state are all the more privileged when served from such a tantalizing menu of ideas by the bar and the bench. Yet my discomfiture, ladies and gentlemen, with the manner in which this issue was brought before the High Court in the first instance still persists. And it bears repeating that in the ordinary scheme of things, a petitioner ought to approach the courts seeking relief on the basis of the real or perceived violation of the Constitution. But to begin by seeking a declaration there exists somewhere in our psyche, beyond and above the Constitution, a doctrine that is nonetheless applicable in our legal system and which we have to take cognizance of even as we embark upon the determination of whether certain actions or omissions have violated the Constitution, is to lead judges onto a terrain hitherto uncharted. It is my firm view that this prolonged debate has been agonizingly stripped of the discipline of judicial inquiry. First, through what I consider to be the conceptual profligacy of elevating a notion to a legal doctrine and embellishing it with an extra constitutional force of law, and then quite inexplicably attempting to locate the minted doctrine into the text of our Constitution. So on the one hand, we are treated to what I can call lyrics of contextualism, while on the other we are strung with thirds of textualism. And so the orchestra, in my view, goes on, which, if not choreographed, could unleash an interpretative odyssey, or maelstrom, if you like, attempts to wriggle therefrom by those to come after us, which could end up in theatrical ignominy. All this while, scant attention has been paid to what I consider a majestic directive principle in our Constitution, a tool of analysis that, faced with such questions as the ones I have posed, a court of law must deploy. And I make reference to Article 259 of the Constitution, the marginal note of which reads, construing the Constitution, or construing this Constitution. And instructively, this provision is preceded by another, which I consider as a defensive armor gifted to our vigilantes of democracy and the rule of law. And this is Article 258(1). And so I go on and on that by the end of the day, in answer to the issue as so formulated, I arrive at a conclusion to the effect that the so-called basic structure doctrine is not applicable in Kenya. I go on to consider the extent if it is so applicable, but having arrived at that conclusion, I then limit myself to some of the statements and pronouncements that were made by the two superior courts, that is to say, the High Court and Court of Appeal. In this process, I arrived at a conclusion that, contrary to what was decided in error, if you ask me, there is no provision in our Constitution that is unamendable. The question for us to ask is whether the Constitution of 2010 has within it comprehensive provisions, directive principles, and normative prescriptions which are capable of withstanding any efforts from whichever quarter of abrogating it, distorting it, or fundamentally changing its equilibrium. That is the question that we should ask. And when I asked that question, I arrived at an answer in the affirmative. So that leads me to the next issue, whether the President can initiate changes or amendments to the Constitution, and whether constitutional amendment can only be initiated by Parliament through the parliamentary initiative. In agreement with my colleagues at the High Court and Court of Appeal, I am of a firm opinion, having read the relevant provisions regarding that issue, and in context, I am of the opinion that the President cannot initiate what is referred to as a popular initiative under Article 255 and Article 257 of the Constitution, because those articles talk about an initiative to amend the Constitution by the people. And the word people here is not an ornamental one. It is a serious expression of what forms what we consider a social contract. And both the High Court and Court of Appeal held that such an initiative is reserved for what they call the common manage. But before answering this question, I have to ask myself as to what really constitutes a popular initiative. In my view, a proposal to amend the Constitution through a popular initiative comes into being when there is a felt need for such an amendment by the people. But care must be, however, taken, as advised by Professor Miguel Akech in his amicus brief, not to anjiconize, no, but that's my expression, not to anjiconize every stage of constitution making or amendment in his comprehensive analysis of the history of the constitution making in Kenya, the good professor, rightly in my opinion, decries the tendency to underestimate the role played by what he calls the political elite in the making of the Constitution of 2010. And why do I agree with him? Because, in my view, a democratic polity such as ours comprises of a complex mix of the ordinary, the elite, and the philosopher, each of whom is entitled to meaningfully participate in the popular initiative of constitutional amendment. Therefore, this felt need to amend the Constitution may find expression in various fora, such as our institutions of higher learning, public symposia organized by civil society, religious and community-based organizations, if you remember the Ufungumano caucuses, and even public rallies, as long as those rallies are not organized under the influence of the political class, especially the elected one. These symposia and caucuses and rallies would have as their main objective the need to firstly clarify the rationale and content of the proposal for amendment, and secondly to sensitize the general public and harness their support for such a proposal. At the end of the day, this felt need will have undergone such repetition, such notoriety, such refinement, and would have acquired such stability and coherence as to be capable of being formulated into a general suggestion or bill as stipulated in Article 2572 of the Constitution. At no stage is very clear to me is the role of the president, co-president, contemplated by the provisions of that article. It cannot have been lost on a casual observer for painful history that it was the imperial presidency that mutilated the independence constitution through unchecked amendments to such an extent that at the end of the day, this country had lost any pretensions to democracy, rule of law, human rights, or social justice. And by the early 1990s, the Kenyan people were terrified, tormented, and dehumanized a lot, deprived of any sense of self-actualization in the manner in which they were governed. It was from such despondency that the people would rise to demand a new social contract, a new order that would not only restore their dignity, but also prevent the executive arm of government, if you like, read the president, and to a certain extent the legislature, from reversing the new equilibrium, from taking them from the paradigm shift to which they had cutted themselves. And so to this question, I have no hesitation in holding that the president cannot initiate a popular initiative. That takes me quite quickly as to whether indeed the president did initiate this popular initiative. It's on record, Vida Gazette notice number 514 dated 24th May 2018, that the president appointed a task force named Building Bridges to United Kenya Task Force, or the BBA Task Force, if you like. This task force was composed of eminent Kenyans whose mandate it was to address the 9 key challenges facing the country. And these challenges have been identified in a memo of understanding signed between the President and Right Honorable Raila Odinga. Thereafter, the President, Vida Gazette Notice number 264, published on 10th January 2020, appointed a steering committee on the implementation of the Building Bridges to United Kenya Task Force report. One of the terms of reference of that steering committee was to propose administrative, policy, statutory, and constitutional changes that may be necessary for the implementation of the recommendations contained in the task force report. It that is out of which the steering committee, that we now have the Constitution of Kenya Amendment Bill of 2020. I, on my part, find, although the High Court later described the task force as an unconstitutional outfit, I, on my part, find that there was nothing unconstitutional in the appointment or composition of either the task force or the steering committee by the President. What remains is whether the President can be regarded as having initiated the process that culminated into the bill that we now have. And in conclusion, I have stated that taking everything into consideration, all the stages, all the processes that led to the bill, I find it difficult to distance the President from the involvement and the initiation of the popular initiative. Therefore, I find that the President did actually originate this initiative. The conclusion deriving from this I shall return to in my final conclusions. And now, next is whether the second schedule to the Constitution Amendment Bill 2020 is unconstitutional. Both the High Court and Court of Appeal found that schedule unconstitutional. I have considered the reasoning by the two superior courts. I have looked at the relevant law, and I come to a similar conclusion that this second schedule to the Constitution of Kenya Amendment Bill 2010-2020 is actually unconstitutional. Fourth, I consider whether civil proceedings can be instituted against the President in person or a person performing the functions of the office of the President during his tenure of office. And I know I've taken into cognizance the submissions by the Attorney General urging the court to find out such proceedings cannot be instituted against the President or a person performing the functions of that office. I also know that there are those who have strenuously opposed the Attorney General's submissions and have argued that such immunity is limited, so limited that the President can on occasion be sued where or if he violates the Constitution and if he violates any other law when he is not acting in his capacity as the President. And I have, having carefully considered those arguments, I find considerable difficulty in appreciating the rationale or basis upon which first the High Court found that notwithstanding the clear and unambiguous language in Article 1432 of the Constitution, that the President can still be sued in his personal capacity for acts or omissions alleged to be in violation of the Constitution. Why did the High Court introduce the phrase "only protected"? And then turning to the finding by the Court of Appeal, I find similar difficulty because it is clear that should the President engage in an act or omission that is violative of the Constitution, there are constitutionally recognized pathways through which such violation can be put right. And I have mentioned and discussed them in the body of my judgment. But a more profound legal reason for presidential immunity in both its private and official capacity is to be found in Article 1433 of the Constitution, which provides that where provision is made in law limiting the time within which proceedings under Clause 1 or 2 may be brought against a person, a period of time during which the person holds or performs the functions of the President shall not be taken into account in calculating the period of time prescribed by that law. And what is this law referring to? It must be referring to the law of limitations. And then why would the president be denied the benefit of limitation of actions? Precisely because the president cannot be sued in his private capacity during the tenure of his or her office. And I also state that once a president, always a president until he or she vacates the office, because you cannot be a president today and tomorrow you are not a president, so that you may be so sued. That brings me to issue number 5, the place of public participation under Article 10 vis-a-vis the role of IEBC and whether there was public participation. And in response to this, after serious analysis, I find that there was no obligation on the part of the IEBC at the time it embarked upon the verification of signatures to satisfy itself as to whether there had been public participation before the bill and signatures were transmitted to it. I do not find anything in the Constitution that obliges the IEBC to carry out that function. But what about the promoters of the popular initiatives? What about Dennis Waweru, Mr. Waweru, Honorable Junet, who have defined themselves as promoters? Were they not supposed to undertake meaningful public participation? The argument that I see here against such a proposal is that the process of popular initiative begins with the collection of signatures. And I do not agree with that proposition, because before you collect signatures, there must be something you are offering the people. You are taking to the people either that general suggestion or a draft bill. And if you are seeking their signatures, surely the people must understand the contents of the bill to which they are appending their signatures. I have read the contents of the affidavit sworn by Honorable Waweru, the contents of which states that there was a comprehensive and robust process of consultation. But the contents of that robust consultation are not clearly stated. And so I'm concluding that when it comes to the promoters of the popular initiative, I do not myself think that they undertook sufficient or meaningful public participation under within the meaning of Article 10 of the Constitution of 2010. And now this brings me to the interpretation of Articles 88 and 250 of the Constitution with respect to the composition and quorum of the IEBC. This one has been thrust to us because somewhere along the line, the petitioners did allege that at the time it undertook the verification of signatures, the IEBC lacked the requisite quorum to be able to constitutionally undertake that task. And then I've also looked at the history of the legislative form that prescribes the quorum of IEBC. I've looked at the contents of the Article 251 of the Constitution, and I come to this conclusion that if, as indeed we must conclude, that at the time the IEBC undertook the verification of signatures, it was constitutionally and properly so constituted, how on earth can we then say that it lacked quorum to undertake the tasks for which it was properly constituted? And then my attention has been drawn to the contents of paragraph 5 of Schedule 12, I think, to the IEBC Act, which sets that quorum at 5. And I'm simply saying that as between a constitutional provision You cannot use the provisions of a statute to override the majesty of a constitutional provision. And having so said, I find that the IBC had the requisite quorum to conduct the verification of signatures and any other task that the Constitution requires it to undertake. And finally, I come to this vexed question of whether the interpretation of 25710 of the Constitution entails that all, or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions. I had no difficulty in disposing of this particular issue because it was not right, as rightly observed by my colleague Tuyot J.A. of the Supreme Court. And I'm not the kind of person to engage in abstract exercises. Because if we did that, then we would be also encouraging Kenyans, as indeed they have done to us in this basic structure imbroglio, to come with abstract questions and expect us to expend valuable judicial time disentangling the same. So what are my conclusions? One, the basic structure doctrine is not applicable in Kenya in the way and manner in which it has been formulated, because it's no such doctrine, neither does it have a force of law juridically so understood. I've said it is a heuristic device. The four sequential steps of civic education, public participation, and the rest are not also applicable to the process of constitutional amendment envisaged under Articles 255, 256, and 257. Such steps, and not necessarily in that order, would become operative in the event of a seismic constitutional moment which dictates that the people must exercise their primary constituent power to make a new constitution or re-establish the constitutional order. And three, the president cannot initiate or activate any constitutional changes through a popular initiative process as envisaged under Articles 255 and 257 of the Constitution. For the president actually did initiate the proposed constitutional amendments, and the effect of that, I believe, should be able to come out in the final disposition of this dispute by this court. The second schedule to the Constitution of Kenya, Amendment Bill 2020, is unconstitutional. Civil proceedings cannot be brought or instituted in any court of law against the president or a person performing the functions of that office in their personal capacity during their tenure of office in respect of anything done or not done in the exercise of their powers under the Constitution. And seven, the IBC is not under any obligation to ensure that the promoters of a popular initiative have facilitated public participation before transmitting the resultant bill to it. But I also say that in this particular instance, no meaningful public participation was conducted by the promoters of this bill. 9, the IBC had the requisite quorum at the time it undertook and completed the verification of signatures. And finally, the interpretation of Article 25710 in the manner in which the issue has been formulated is not ripe for consideration, not just by this court, by any other court in this country. Before I sign off, my mind races back to those 3 days in this tent during which I and my colleagues here sat patiently, pensively and attentively, listening to the impassioned pleas from the bar so commandingly assembled. Not that this was the first time I was finding myself having to endure the preparations of counsel, some of them experienced jurists and others not so senior. But it was such a moment when the basics of a basic structure were basically spewed unto us with such aplomb, hitherto unseen, save during the hearing of our presidential election petition. What we were told, however, I also remember that it was on such occasion that we were reminded that our colleagues at the High Court and Court of Appeal, the colleagues at the High Court had built a foundation, and those ones at the Court of Appeal had constructed a wall upon it. And now it was our turn to paint that wall. But we were not told with which colors we were to undertake this alluring task. I also remember being urged to roar like lions in the wild as we asserted the supremacy of the Constitution. But who could fault counsel for invoking our hallowed symbol of nationhood? Yet at that moment I could not help but cringe, for the sound of a roar of a lion in the wild stirred in me images of the terrifying language so beloved by our politicians, the language of tsunamis, of earthquakes, volcanoes, war and thunder. And that's why I cringed. And then I remembered that not so long ago this court had in one of its judgments, and really in true oracular rendition, or so I thought, decreed as follows. But it does appear, as my colleague Judge Lenaola here apprehended, counsel do not read the judgments of this court, and now I am forced to read this decree to you, so that even if you don't read it, it shall be etched in your mind. And this is what this court said at that time. What of the argument that this court should not subvert the will of the people? This court is one of those to whom that sovereign power has been delegated under Article 13C of the same Constitution. All its powers, including that of invalidating the presidential election, is not self-given nor forcefully taken, but is donated by the people of Kenya. To dishonestly exercise that delegated power and to close our eyes to constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular that invitation may seem. Therefore, however burdensome, let the majesty of the Constitution reverberate across the lengths and breadths of our motherland. Let it bubble from our rivers and oceans. Let it boomerang from our hills and mountains. Let it serenade our households from the trees. Let it sprout from our institutions of learning. Let it toll from our sanctums of prayer. And to those who bear the responsibility of leadership, let it be a constant irritant. So I say no more. Thank you, Chief Justice.
Thank you very much, Justice Wanjara, for that addition. I now request the Honorable Mr. Justice Ibrahim Mohammed to deliver his opinion.
Thank you very much, Honorable CJ, the President of the Supreme Court of Kenya. Every judicial officer or judge has this style of delivery, but when there is a pressure of time, you elect how to do it, considering the question of time also. The art of brevity does not come or are not bestowed on everyone. So you may find that I may take a bit longer on some issues, but to save time also, I may summarize. I may give a summary of my findings in some of the issues, and also the dispositions on each issue, while in others I may give some more elaborate explanation for my conclusion and disposition. The Honorable Chief Justice and President of the Supreme Court of Kenya, Honorable Lady Justice Martha Koome, has in the lead judgment aptly captured the history and background of the appeals before us. She has also pertinently set out the written and oral submissions by all counsel, as well as the amnesty, for which I thank her on our behalf. I see no need to replicate or rehash the same. I refer to the 7 issues which were framed by the court on the 9th of November 2021. The 7 issues, I'll not read them out. Thank you. I'll not read them out as they are already on record and have been referred to by all my colleagues. I'll also refer to them one after the other. I find myself substantially in agreement with the arguments and conclusions by the Honorable Chief Justice Koome, President of the Court, on some issues. Just as well, on some I'm of divergent views. I render my opinions and pronouncements on the issues as delineated by the court. The first question is regarding the basic structure, whether it's applicable in Kenya, and if so, the extent of its application, whether the basic structures of the Constitution can only be altered through the primary constitutional power, and what constitutes the primary power. In answering and determining these questions, I trace the history of what is the basic structure and what it comprises of in the framework of a constitution. I trace that history globally, from the Federal Republic of Germany to India, the US, France, then also to the other countries like Malaysia, Singapore, Bangladesh, Uganda, and many more. Some of these states, particularly the ones which came to consider later the basic structure, some were disinclined initially. That's the courts in those countries, but later some of them adopted and accepted the same doctrine. I finally came to the applicability of the same doctrine of basic structure to Kenya. I followed our journey of constitutional making from the CKRC to the Bomas Conference. During the same process, Justice Rigera, as he then was, grappled with the question of the basic structure of our repeal constitution. He concurred with the majority pronouncement in the case of Kesavananda that Parliament did not have the power to alter the basic structure of our constitution. This was in the case of Timothy Joya and others versus CKRC and another. The application of the doctrine arose in the case of Patrick Ouma Onyango and 12 others versus AG 2008. The court, consisting of Justice Nyamo, Wendo, and Mkule, found and declared that the basic steps in constitutional making, they declared the basic steps in constitutional making. Then there was the case of Commission for the Implementation of the Constitution versus National Assembly of Kenya, 2013, where Honorable Justice Lenala, as he then was, analyzed the question of the basic structure of the Constitution, although that was not really a direct issue, and also the issue of its applicability was not before the court. I just want to refer that it was considered and it was a known principle before this case, which is before us. Then there was the case of Priscilla Ndululu Kibuitu and another versus AG 2015, wherein the 3-judge bench, Korir, Mumbi, Ngugi, and Odunga, held that some amendments under Article 255, 1 or Article 257 can only be done with the involvement of the citizens by way of referendum. They relied on the sentiments expressed by Honorable Ringera J. in the Njoya case. The three judges, I'll refer to paragraph to what they said. I'll go directly to that, what they said. They say that we agree with the sentiments expressed by Ringera J. in Njoya 2 that an amendment that upsets the basic structure of the Constitution could not be effected by Parliament without involving of the people. In a country like ours, which has a history of disrespect for the sanctity of the Constitution, the jurisprudence propagated in the Njoya 2 case was necessary. This may explain why the people of Kenya, aware of the frequent and frivolous amendments to the repealed Constitution provided in Articles 255 of the 2010 Constitution, and I refer to the contents of Article 255, where strict conditions were given before any amendments could be carried out, and I don't have to refer to that. It is clear from the above cited provision that there are amendments that can only be done with the involvement of the citizens by way of a referendum of Article 255(1) or popular initiative involving at least 1 million registered voters, Article 257(1). So it means that the judges themselves in this case, referring to the basic structure, identified Article 255 as containing principles of basic structure. Even where Parliament has been mandated to amend the Constitution, it can only do so after the amendment bill has been subjected to public discussion. Article 256(2). The voice of the people is a voice that cannot be ignored when it comes to the amendment of the 2010 Constitution. We wonder, and they continue, we wonder whether in light of the provisions in 2010 Constitution, the proposition that Parliament cannot amend the Constitution in a manner that may result in the distortion of the basic structure, again they use the word basic structure, still has a place in our jurisprudence. However, this is not an issue that has been taken up and with us, and we will say no more about it. So I'm just giving the background that these issues have been before the court, but not directly. But now, in our case, it is directly before us, and we have to deal with. There has been a discussion and contestation of whether this basic structure is a doctrine or even a principle. An uncontentious example of popular doctrine, for instance, is that of the separation of powers in a tripartite form of separation comprising the executive, judiciary, and legislative arms of government. We credit the French jurist with a long name, Charles Louis de Secondant, Baron de la Brede de Montesquieu. I'm not very good in French. In fact, I don't know French at all. Or Montesquieu, I read him in history, simply referred to as Montesquieu, as the father of the doctrine. This doctrine is embedded in our legal system by direct reference in various, and we have adopted it even in the structure of our Constitution. However, even as we make reference to the doctrine of separation of powers today, it is not to say that the doctrine has not evolved since 1748, or that it is only Montesquieu who discussed it. In Kenya, we have not only laws, however, That incorporation was with some modification to suit our peculiar circumstances, such as the addition to the independent commissions and offices. Yet in doing so, we have not explicitly provided for it, or even defined the doctrine of separation of powers in our laws. Still, it is evident that we have applied it. So the question of the basic structure as a doctrine, what is it? What does it encompass? Is it applicable in Kenya? This is the duty we have, and we cannot just dismiss this. It is many times it has been said that this doctrine of basic structure, the origin came from the case of Kesavananda, 1973, whereby the majority of 7-6, the court in India, Supreme Court, held that the Article 368 of the Indian Constitution does not enable Parliament to alter the basic structure or framework of the Constitution. And there's a quotation or citation by two judges, Justice Hedge and Justice Mukeji. But after tracing the history, we find that actually these principles did not emanate from India. It emanated from the scholar that a colleague referred to that. The scholar called, there's a Professor Conrad of Germany. He gave us a talk in some Indian university, and this idea was captured captured by some lecturers and some professors, and finally it reached the ears of some judges who, in the case of Golaknath versus State of Punjab, 1647, who applied those principles, and that was the first foothold in India, that case of Golaknath. Even though the court then did not accept any limitations on Parliament's power to amend the Constitution. So, regarding the Germans, it's not easy to see why a German jurist would propagate implied limits to amending the constitutional powers. Article 79.3 of the Basic Law of the Federal Republic of Germany, adopted on 8th of May 1949, explicitly bars amendments to provisions concerning the federal structure and to basic principles laid down in Articles 1 and 20 on human rights and democratic and social setup. The Germans were healing from the Nazi era, and it is for that reason that the framers of the Basic Law sought to create a constitution that will safeguard against the emergence of either the Weimar Republic's overly fragmented multi-party democracy or the Third Reich's authoritarianism. And there have been arguments in various cases in support of this. Now, in France, the same thing happened, where a scholar called Schmidt was where a scholar called Boris Hario, a professor of administrative law and constitutional law, published two constitutional treatises, and the difficult name it has, I can't read it, setting out the history of implied limits on constitutional amendment. Now, coming back to, I'm referring now how this has been discussed in Kenya. Yannick Rosner, in his article on constitutional amendments, the migration and success of a constitutional idea, in the American Journal of Comparative Law, drew attention to the debate of the First American Congress, more particularly the debate that took place on August 1789. So there's a lot of discussion in the US, and I don't have to go to the cases. Everything is in that judgment. I've gone rather into some detail. Legal doctrines and principles are often traceable to a particular school of thought, and more specifically to to certain scholars who sought to elaborate them. The importance of this is to address the contestation regarding whether the basic structure doctrine was a creature of judicial craft, or even whether the courts are capable of creating doctrines. This is not to make a case for incorporation or rather reading into our laws. All doctrines and legal principles are in existence. From this, however, it is evidence that the doctrine of basic structure was not invented by the judiciary in India and some of the other countries. It has been submitted that the doctrine of basic structure has yet to gain universal experience. And for that reason, we are asked to find that it is not applicable. I do not think it is necessary that before application of a doctrine or legal principle, the same must have universal application. I say this because not all legal doctrines and principles are universally applicable due to the differences in legal systems, such as the civil and common law. This is also because of our unique peculiarities, such as states due to our historical, cultural, and social systems. My thoughts on this are further fortified by our Constitution, read together with the Judicature Act, Cap 6, laws of Kenya, which allow us to apply the doctrine that are in line with our laws, more so if they assist us better to interpret and apply them. There's a lot of reading material which I've referred to. So basically, directly is the doctrine. Is the doctrine of basic structure applicable to Kenya? The basic structure doctrine is not only new to our is not entirely new to our jurisdiction. Much like the other countries, Kenya has had opportunity to grapple with the doctrine of basic structure in our circumstances. During our journey of constitutional making, with the CKRC appointed in November 2000, the commission chaired by Professor Yash Palgai convened the National Constitutional Conference for discussion, debate, amendment, and adoption of its report and draft bill, famously dubbed the Bombers Conference, due to taking place, which was taking place at the Bombers. The Bombers Conference was convened and adjourned 3 times, out of which a draft was amended and adopted by the acclamation by the conference, sitting in plenary on 23rd March 2003, then handed over the constitution to the Kenya Review Commission. However, before the conference was adjourned, there was a number of challenges to the validity or legitimacy of the entire constitutional review process and its outcome. One of which was the case that I referred to, Timothy Joya and others, versus CKRC. The applicant sought inter alia, that was 2004. The applicant sought inter alia a declaration that certain provisions of the Constitutional Review Act transferred, diluted, and vitiated the constitutional power of the people of Kenya to adopt a new constitution. The court held that the new constitution needed to be ratified through a national referendum, as the right to a referendum was a fundamental right of the people in exercise of their constitutional power. Brigadier J, who is now retired, who was in the majority, concurred with the pronouncements of Kesavananda that Parliament did not have the power to alter the basic structure of our constitution. And there is a citation here, which I don't have to go through, where Justice Rigera, and which means our courts, recognized the principle of, this is my submission, principle of basic structure. Application of the doctrine again arose in the case I referred to, Patrick Ouma Onyango. One of the issues that arose was whether Parliament, in its limited delegated role, had the power to debate, alter, or amend the Bombers draft constitution, which was the product of the view of the people. It was also questioned whether that interference by Parliament had the effect of elevating the members of National Assembly above the people of Kenya as sovereigns. The court, consisting of Nyamo, Wendo, and Mkule, held, and I think I should refer to it very quickly. We further find and declare that what will give purity to the process is the enactment of the proposals as a constitution by the people in the referendum. It is the enactment by the people which gives purity and validity. Yes, they are the touchstone of validity. The people. The applicants in their final written submissions did concede that constitutional power cannot be restrained. We exercise judicial power on behalf of the people, and we cannot restrain for them in making their choice. These are three judges of our courts speaking for the people of Kenya. We find and declare that the basic steps in constitution making are 1. Popular consultations, 2. Framing of the proposals, 3. Referendums or constitutional assembly elected and mandated. We find the challenge process has satisfied all the 3 steps. We find and declare that the process is not flawed. In our view, the real judges of the process are the people of Kenya, in view of the past involvement with the process as outlined. I'm not going to go through all that. There's a lot of material which I'll let you read when you get this judgment. Basically, it is to show that Kenya itself, due to the constitution making process that led to 2010, people discussed in depth the history and the problems that Kenya went through, the hyper amendments that we had gone through, and the result was the 2010 Constitution, and in particular Chapter 16 and Articles 255, 256, 257, which I will be persuading you in this opinion that contains the basic structure that supposed to protect the people from amendments by even the delegated power, which is Parliament. After the promulgation of the Constitution in August 2010, there was a case of the Commission for the Implementation of the Constitution versus National Assembly of Kenya, where the National Assembly, by the Constitutional Amendment Bill 2013, sought to amend Article 260 of the Constitution in respect of the definition of state office. I already discussed that. Then there was the case of Presida Kibuitu. Then we have various cases, Attorney General versus Randon Zai, whereby the court held that in view of the foregoing, the appearance contention that the respondent's agenda of succession is unconstitutional has no basis in law. The respondents have a constitutional right to demand succession, but that can only be done within the confines of the Constitution as stipulated under Articles 255, 256, and 257 of the Constitution. Now, in all these cases, the applicability of the basic structure doctrine was not a substantive question of the courts. The courts were asked to determine, unlike the present one. So, in this case, through my proposals here, which I don't wish to go through, and I told you the art of brevity is not donated to everybody, and I'm not one of them. So I'll let you read. But I'd refer to what I've said here. That there was this decision by Justice Mativo in the Third Alliance case, Kenya versus head of public service, Joseph Kinyua, and others versus Martin Kimani and others. In that case, Justice Mativo said he referred to this doctrine and he stated as follows: the command in Article 259 is instrumental in shaping the constitutional jurisprudence in this country. Call it by any name, basic structure, or whatever, but Article 259 provides the manner in which the Constitution is to be interpreted to maintain its fabric, which cannot be dismantled by any authority created by the Constitution itself, be it the Parliament, the Executive, or the Judiciary. Couched in this doctrine are a few crucial aspects. First, that constitutions are considered to be the act of the people as the almighty sovereign. We see this as the power of the people recognized and documented in the preamble of our constitution, which begins as follows, and I quote: "We, the people of Kenya, exercising our sovereign and inalienable right to determine form of government of our country and having participated fully in the making of the constitution." So I've gone through this and I invited you, as some of my colleagues have said, some of our judgments are long. Mine is 125, and it is, I would not wish to read through it. I invite you to read carefully, but after going through all my arguments and citing various cases and showing the historical road we passed to acquire, to get this very important Constitution 2010, of which I'm sure all of us are proud of and all of us cherish, I came to the conclusion by disposition on this issue, first issue, noting our history, context, and constitutional text, I find that the doctrine of basic structure is applicable to Kenya. Further, that the basic structure of a constitution can only be altered or denatured through the primary constitutional power. C, it's my further finding that the primary constitutional power is the unbound power of the people to make or unmake constitution, and genuine exercise of the same can be identified by the four sequential steps of civic education, public participation, constitution assembly, plus referendum. So I've set out in the judgment what the basic structure entails. And I've set out and I've discussed the issue where can the basic structure of the Constitution only be altered through primary constitutional power, and what constitutes the primary power. I've discussed that, and that was my dispensation. So that is my dispensation in that question, and I invite you to read that. So in the interest of brevity of time, I'll go to another issue. Issue number 2. Issue number 2, whether the President can initiate changes, amendments to the Constitution, and whether constitutional amendment can only be initiated by Parliament through a parliamentary initiative under the Article 256 of the Constitution, or through a popular initiative under the Article 257 of the Constitution. I'll give a summarized view of this, which is contained in this opinion and judgment. And also one more issue. The other issue is the place of public, issue number 5, the place of public participation under Article 10 vis-a-vis the role of IBC. The other 3, I wish just to set out and read and state my disposition without going into the details, and I leave that to you to read when you have the time. Regarding question 2, Gatebu J.A. rightly observed that Article 257 makes no qualification of who may or may not promote a popular initiative, and there is no explicit bar against any person, including the President, from promoting a constitution amendment by popular initiative. It is therefore upon the court to interpret and determine the parameters of the same. Now, Justice Tuyot gave the historical context of highlighting the genesis of popular initiative, the clauses in the Constitution. This can be traced back to the CKRC final report, where the Commission noted that although the Conference agreed the process of constitutional amendment, this must not be left entirely to Parliament. Different options needed further thought, particularly with regard to the exact modalities of engaging the constitutional power of the people. The Commission, in addressing the issue, recommended that that citizen and the civil society may initiate constitutional amendments through a process called popular initiative. This was then captured in the zero draft at Article 346, and the same was retained in the Boma's draft as follows, and I quote, an amendment to this constitution may be proposed by a popular initiative signed by at least 1 million citizens to vote. So the genesis of the issue of popular initiative was way back during the CKRC conferences. The same survived the Naivasha Accord of November 2004 and the Kilifia Accord of June 2005. And also, it was retained in the harmonized draft. The objective for the popular initiative, as captured by the final report of the Technical Working Group of Group K of the Constitution of Kenya Review Commission on Constitutional Commission and amendments to the Constitution held up to the creation of 2010 Constitution, the report said a committee introduced a novel idea called popular initiative. This is an innovative where the citizen can only by their own motion initiate amendment to the Constitution by way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament. Tuyot JA went to hold that, contrary to the AG's submission that the intention of the popular initiative was to curb parliamentary monopoly for both people and state organs, the historical perspective demonstrated that the popular initiative was a preserve of the citizens. It's for this reason that I concur with Kiage J when he concluded that the popular initiative route must be citizen-conceived, citizen-initiated, and citizen-driven process, and the citizens are the ordinary people, whether as individuals or as organized civil groups. Regarding the assertion that the President can initiate process of constitutional amendment by way of popular initiative in his capacity as a private citizen, two pertinent issues arise. First is the fact that Article 257.5 subscribes the President a role in the amendment process. Article 257.5 provides that if a bill to amend the Constitution proposes an amendment relating to matters under Article 255, the President shall, before assenting to the bill, request IBC to conduct a national referendum within 90 days. The import of this provision is it assigns the President the power to decide whether or not to hold a referendum. To ensure the integrity of the process of constitutional amendment pursuant to Article 257, we cannot have the President playing the role of umpire, who is expected to be neutral and act in the interest of the nation, in a process where he is also a player advocating for his own personal interests and agendas. Clearly, there would be a serious conflict of interest. This would be detrimental to the interests of the people and the nation. Second is that the President ceases to be an ordinary citizen the minute he takes office. Article 131 describes him as the head of state and government, who exercises executive authority of the Republic. He is also the Commander-in-Chief of the Defense Kenya Forces. He chairs the National Security Council pursuant to Article 240, which exercises supervisory control over national security organs, including the Kenya Defense Forces, the National Intelligence Service, and the National Police Service. He is also the symbol of national unity. He plays the various powerful roles pursuant to Article 132, including appointing Cabinet Secretary, Attorney General, principal secretaries, high commissioners, ambassadors, as well as diplomatic and consular representatives. He is empowered by virtue of Articles 132, 4D and E to declare a state of emergency or declare war, respectively. He may also, pursuant to Article 192, even suspend county governments, either in emergency arising out of internal conflict or war, for any other exceptional circumstances. By virtue of holding this office, the President is accorded immunity with Article 143. So you can see the special position of the President. And we are saying, and I'm saying that the President cannot act as a promoter or initiator, even if you have to use that name, initiator, you cannot commence or get involved. In this particular case, there is evidence that not only did he start the process, but he was also involved throughout, and all steps taken by others the genesis was his own actions through the Gazette notice and the legal steps that he took. This power and control that the President exercises by virtue of his position was evident in the inception of the amendment bill, as rightly pointed out by the learned judges of the superior courts, right from the handshake that was between him as the elected president following the contentious 2017 general elections and rerun, and his competitor and challenger, Honorable Raila Odinga. He then proceeded to appoint that. So I gave, in this narration, I give the history of all the steps that he was involved in directly, building bridges to a united Kenya, from a nation of blood ties to a nation of ideals, the appointment of the teams, the Gazette notices throughout. The first step had a domino effect, and throughout he was involved, and the government's role was also very clear. The difference in the amendment bill that was launched on 25th November 2020 from the amendment bill contained in the BBI Steering Committee report presented to the President on 26/2020 are better contextualized in discussing the place of public participation under issue number 5. My conclusion there is that on whether the President can initiate a popular initiative to amend the Constitution under Article 257, it is my finding that he cannot. Issue number 3, on whether the second schedule to the Constitution of Kenya Amendment Bill 2020 was unconstitutional, I find that on issue number 3, I find that the second schedule of the Constitution of Kenya Amendment Bill to have been unconstitutional. On question number 4, it is my finding that pursuant to Article 143(2), no civil proceedings can be instituted against the President or person performing the functions of the office of the President during their tenure of office with regard to anything done or not done contrary to the Constitution. And regarding public participation, I wanted to say more, but I will wish to save time, and I will invite you to read the judgment. On issue number 5, I find that by the time the process was stopped by the High Court, the public participation undertaken was not sufficient, reasonable, or meaningful. Issue number 6, I find that the IBC was not properly composed or queried while it undertook the verification of signatures pursuant to Article 257(4) of the Constitution. However, In the light of the decision in Isaac Biot case, IEBC's undertakings in compliance with the decision were lawful. Number 7, it is my finding that the interpretation of Article 257(10) on whether the proposed amendments should be submitted to the people as separate but distinct referendum questions, this issue was not ripe. For determination for determination. On the issue of costs, I recommend that being a public interest matter, the parties ought to bear their own costs of proceedings in the High Court, Court of Appeal, and in the present appeals. The final orders of this court are as will be contained in the lead judgment of the Chief Justice and the President of the Court, at which he will advise the court before we end these proceedings. I've had to do this, but I invite you please carefully read my whole judgment. Thank you.
Thank you very much, the Honorable Mr. Justice Ibrahim Mohammed. Allow me now to invite the Honorable Justice Mwilu, the Vice President of the Court, to render her opinion.
Thank you very much, Judge President. The modus operandi today from the side of the court was to deliver summarized versions of the judgment. The 150 plus pages will be at your disposal at your time that the President of the court shall advise. The lead judgment carries all the background to the case quite comprehensively, the history of these proceedings, the fact submissions of all the parties, and the prayers sought. I see no need to rehash that. But at a personal level, I shall read what I consider to be brief. The rest, those who are interested in reading judgments afterwards, shall read. To me, democracy is a perpetually contested condition. Within it, through discourse, persuasion, contention, and reconciliation, we are constantly in mutability towards improving our condition through perfecting the substance of the norms and agreements by which we agree to coexist and flourish. Whilst we see this across our courts every day, there are certain matters that attenuate our constant pursuit of socio-political perfection. The petition before this court is one such. Within the context of our national journey towards perfecting our constitutional democracy, the important role of this court and all parties to this petition becomes all the more apparent. The crux of this petition, as I said, is the extent and nature of constitutional amendment in Kenya, especially within our nation's history of constitutional development, and more specifically, the experiences and processes that birthed the Constitution of Kenya 2010. Any initiative that seeks to change that body of fundamental principles according to which we as Kenyans have agreed to be governed, our Constitution deserves the most attention of all Kenyans, whose duty under Article 3 is to respect, to uphold, and defend the Constitution, and all state organs who under Article 2 exercise their delegated authority only through and in accordance with that Constitution. The history of constitutional development in Kenya has been laid out concisely and in detail, both in the High Court and the Court of Appeal, and even in our decisions. This history is most relevant, in my view, This court, the Supreme Court, has on numerous occasions asserted the importance of historical context as a key tool for courts and tribunals in the interpretation of the provisions of our transformative charter. Though a significant factor, it is not and ought not be the only lens through or the weightiest factor upon which we consider the questions of constitutional interpretation. Professor Richard Albert referred to in both the judgments of the superior courts below speaks of the, quote, rise of unamendability, unquote, and the quality of formal amendment rules in terms of their availability for both good and ill, as posing a challenge for constitutionalism in that though rules of change are indispensable for the functioning of constitutional democracy, they at once, quote, open the door to the demise of constitutional democracy itself, unquote. Therefrom, he poses the question, how then, quote, can we protect constitutional democracy from the misuse of its own devices, unquote? The late Professor H.W. Okoth-Ogendo illuminates this discussion by pointing out that it is pointless having a constitution if constitutionalism is not our concern. I am most cognizant of our history as a country as well as the history of the development of our much cherished 2010 Constitution. I'm also aware of the principles developed by this court regarding historical context in the interpretation of the Constitution, a living document that speaks from the past through the present to the future. I must, however, state that the role of our courts must remain within the architecture of the Constitution. It is bound by it. All courts are bound by it. The exercise of discretion must be judicious, though it is the court's task to breathe life into the Constitution and to ensure that its text is constantly speaking to the transformative and emancipatory ideals therein. On the other hand, the text of the Constitution cannot be seen as devoid of meaning and content, merely to be filled by ideas and opinions by those on the bench, no matter how laudable and noble and well-intentioned those may be. A balance must be maintained, and such balance is crucial to the very architecture of our constitutional democracy, for the courts too must not see themselves as immune to being inimical, despotic tendencies. This is especially true in regard to constitutional amendment and the exercise of sovereignty as acknowledged in the Constitution directly and indirectly through processes that are prescribed in our Constitution. The courts must seek to steadfastly and purposely defend and protect the Constitution and constitutional processes through which the people of Kenya express their sovereign power, not on the basis of justifiable apprehension, and no matter the nobility of the cause, employ judicial craft to retain certain moral or doctrinal limits into the exercise of such sovereign power. It is the sovereign, the people who must decide, and responsibility of all state organs only exercise state authority is delegated by the sovereign. That is to remove all extra constitutional impediments to the free exercise of such sovereign power. This constitution has been stretched in its over 10 years existence, and perhaps this is the most serious attempt yet to espouse its limits in the wake of attempted amendments. To demonstrate the magnitude of this case before these courts, while the High Court framed 13 issues for determination arising out of the consolidated petitions, the Court of Appeal expanded them to 21. On our part, we found 7 that required determination, and that's what we are doing this morning, this afternoon. That said, I now proceed to determine the 7 issues as framed in summary as my understanding of the Constitution and the law allows me to do. And the first issue is that doctrine and the basic structure itself. If a doctrine is a legal principle of long usage that is widely accepted as such, then my finding is that the Kesavananda case is a judicial reasoning which cannot be elevated to a doctrine above the Constitution. And therefore, the Constitution of Kenya 2010, I find, has a basic structure. But as for the basic structure doctrine, I find that the same is not derivable from our Constitution, and that structure, wherever else it may be found and applied, does not, in my view, apply in the Kenyan constitutional context. The manner and process through which sovereign power is exercised in this country is by the citizens in its different forms and is fundamentally important under our constitutional architecture, and the Constitution can be changed through other mechanisms, not limited to the primary constituent power. The second issue, the President, in my reading of Article 143, cannot, no, not 143, sorry, Article, issue number 2, the President cannot directly initiate changes or amendments to the Constitution. An amendment of the Constitution can only be initiated through a parliamentary or popular initiative under Articles 256 and 257 of the Constitution of Kenya 2010. Consequently, therefore, the Constitutional Amendment Bill 2010 is unconstitutional. On the third issue, the second schedule to the Constitutional Amendment Bill 2010, I find no difficulty in finding that that bill is unconstitutional insofar as it directs the IEBC on not only the elimination of the number of constituencies but also the distribution of the proposed new constituencies and the timelines within which to operationalize the same within the constitutional parameters that are given in Article 87 of the 2010 Constitution. The Commission cannot be directed. Article 89 was not even sought to be amended in its entirety. The bill, therefore, is unconstitutional in my finding. On issue number 4, even before I decide whether or not the President be sued first, it's important to note that there really was no proper service of the process, and the President was therefore not accorded an opportunity to participate in the pleadings in his personal capacity, as he had been sued in his personal capacity. And I find further that Article 143, any interpretation of that article must come to the conclusion that the President or the person performing the functions of the office of President cannot be sued during tenure. And although their immunity is not absolute immunity to impunity, it is nevertheless absolute immunity during the tenure of office. In my judgment, you will see that I have said if any proceedings were begun before assumption of office, they are stayed. That's what the Constitution says, and they are resumed or fresh ones initiated after leaving office. On public participation, issue number 5, I have said where it mattered most, I found no reasonable or any degree of public participation, which is a value in Article 10 of our Constitution that I could consider allowing the standing of the actions that were done without public participation. This court set the test in BAT versus the CS Health, and I find therefore that for me the test was not met. On issue number 6, the totality of my finding, even considering what the findings in Isaiah B. Watt and in the Katiba case and the effect of the Katiba case on Section 5 were, I would rest with Article 250 of the Constitution and say that the IEBC was not only properly constituted with the minimum number that was required by Article 250, it had quorum, and nothing was shown to the contrary. The last issue, on the last issue as to the referendum question, I agree with all my colleagues in this court and in the courts below that have said that the matter was not ripe. It still is not. The bill never went past the IEBC for it to be submitted to referendum. I find therefore that engaging in a discussion in that matter is a complete waste of precious judicial time, and I will not get myself entangled in such a non-issue as that one. As to costs, this being a public litigation issue, I would say that they lie with each party, and those are the orders. The body of the judgment shall give my explanations for each of my findings. I thank you, Judge President.
Thank you very much, the Honorable Lady Justice Mwiru, Vice President, for that rendition. Before I read the final disposition of the court, allow me to express the court's appreciation to all counsel and all parties and amici appearing in this matter for your erudite and well-researched oral and written submissions. We also wish to thank you for patiently sitting and bearing with us for the last 6 hours as we delivered this judgment. The court notes in a special way the galaxy of legal luminaries, among them distinguished legal scholars, professors of constitutional law from Kenya and other jurisdictions who joined this case to enrich our judgment. We found their views very useful, although they were varied and divergent, especially on the applicability of the basic structure and doctrine and whether it had acquired international application under the provisions of Article 2.5 of the Constitution. The court's decision has been enriched and benefited a great deal from the arguments advanced by all the parties who appeared before us. We hope with the full noise of time, even our local scholars will find their way in other jurisdictions, in other countries, America, Germany, or even Africa, to share our rich jurisprudence with those courts. We also wish to thank our law clerks for their research and exceptional industry in supporting the work of this court. That said, in the course of writing this judgment, the court observed with concern some commentaries on the pending judgment carried out in the social media by some counsel, some of whom are appearing in this matter. The contents of those social media commentaries were, in our view, meant to influence, intimidate, or scandalize the court. This unfortunate practice is emerging, and unless it is checked, it will erode the confidence and the dignity of the courts. It would also amount to unprofessional conduct, especially by counsel appearing in this matter, and even counsel who are not in this matter, but know very well that they cannot comment on a matter that is pending judgment. It is a well-established practice that counsel and indeed parties should refrain from directly or indirectly trying to improperly influence the courts to rule in one way or the other. Once judgment has been reserved and judges retreated to consider submissions and write judgment, learned counsel Mr. Nelson Avi and Ms. Esther Angawa, who appeared for the first to the fifth respondents, took to the social media, Twitter, on different occasions. On 19th February and 15th February 2022, and they cast aspersions on the courts. For counsel to appear before the apex court, then proceed to hurl unnecessary diatribe, insults, and speculations on a pending judgment amounts to unethical conduct on the part of the counsel. The use of social media to disparage the court with the intention of lowering the dignity and the authority of the court or influencing the outcome of the case pending before the court is a trespass on the bounds of legitimate advocacy and moves to the realm of professionalism to professional misconduct. This is in line with the provisions of Section 61 of the Advocates Act that deals with dishonorable conduct incompatible with the status of an advocate. Equally culpable is the conduct of senior counsel, Mr. Ahmed Nasir Abdullahi, who, though not counsel appearing in this matter, took the real role in disparaging and besmashing the court as evidence from his posts on Twitter on 8th February 2022, 15th February, and even as late as yesterday, the 29th March 2022. Section 17 of the Advocates Act envisages the rank and dignity of senior counsel is conferred on the basis of irreproachable professional conduct and exemplary service to the legal and public service in Kenya. These standards are expected to continue even after conferment of the rank of the senior counsel. Advocates should familiarize themselves with the code of standards of professional practice and ethical conduct, Gazette Notice number 5212, and strive to conduct themselves in a manner that preserve and strengthen the dignity, the honor, and the ethics of the profession. Consequently, advocates should refrain from conduct that amounts to indirectly attempting to influence decisions pending before courts. Relevant to the use of social media, we wish to draw the attention of advocates to the standard of professional practice and ethics conduct number 10 that spells out what is inappropriate conduct. This caution should always play in the mind of advocates who are tempted to utilize social media to advance their cause. I will now proceed to give the final disposition of the court. Having considered the 7 issues framed by this court for determination, the final orders are as follows. 1. The basic structure doctrine is not applicable in Kenya. Ibrahim, Supreme Court Judge dissenting. B. In order to amend the Constitution of Kenya 2010, the 4 sequential steps as pronounced by the 2 superior courts below are not necessary. Ibrahim, Supreme Court Judge dissenting. On the second issue, the first part A, the President cannot initiate constitutional amendments or changes through the popular initiative under Article 257 of the Constitution. Njoki Ndong'o, Supreme Court Judge dissenting. The B aspect of that issue 2, the President initiated the amendment process in issue. Njoki Ndong'o and Lenaura, Supreme Court Judges dissenting. Consequently, under Article 257 of the Constitution, the Constitution Amendment Bill of 2020 is unconstitutional. Njoki Ndong'o and Lenaura, Supreme Court Judges dissenting. The third issue, the second schedule of the Constitution of Kenya Amendment Bill 2020 is unconstitutional for being in breach of Article 10(2) and 87(7)(a) of the Constitution of Kenya 2020 for lack of public participation. Njoki Ndong'o, Supreme Court Judge concurring. 4. Civil proceedings cannot be instituted in any court against the President or the person performing the functions of the office of the President during their tenure of office in respect of anything done or not done under the Constitution of Kenya 2010. That was unanimous. 5A, there was no obligation under Article 10 and 257(4) of the Constitution on IEBC to ensure that the promoters of the Constitution of Kenya Amendment Bill 2020 complied with the requirements for public participation. Unanimous. B, there was public participation with respect to the Constitution of Kenya Amendment Bill 2020. Mwiru, Vice President, Ibrahim and Wanjara, Supreme Court judges, dissenting. Five, IBC had the requisite composition and quorum to undertake the verification process under Article 257(4). Ibrahim, Supreme Court judge, dissenting. Seven, the question raised regarding the interpretation of Article 257(10) of the Constitution on whether or not it requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. Joaquin Dongo, Supreme Court Judge, concurring. Each party shall bear their own cost, this being a public interest matter. Consequently, the consolidated appeal is determined as follows. The appeal is allowed on issue number 1. The appeal is allowed on issue number 4. The appeal is allowed on issue number 5. The appeal is allowed on issue number 6. The appeal is allowed on issue number 7. The appeal is disallowed on issue number 2. The appeal is disallowed on issue number 3. Those are the orders of the court. Ladies and gentlemen, thank you very much for your patience. We will seek your indulgence to perfect the final judgment. As you can see, we have so many pages to put together to come up with one judgment. Putting it together, it was very difficult because of the privacy involved and the logistics to put it together before delivery. We intend to do this and issue the judgment of the court on Tuesday next week. Today we will issue a press summary of this judgment, which will come out shortly in about 1 hour. Thank you very much for your forbearance and for your cooperation. Is your mic on?
Thank you. I was saying, Madam President, Madam Deputy President, Your Ladyship, my Lords, we take this opportunity on behalf of Council to thank you most sincerely for your very detailed decision on these very difficult and fundamental issues which have the effect on the future progress of constitutionalism in this country for many years to come. I think I talk on behalf of all council when I say they are very grateful for your patience, your industry, and the detailed means and effect by which this judgment has been delivered. I also take this opportunity to apologize on behalf of Solicitor General, who was here representing the AG, but had to leave because he is before another bench. Thank you, my ladies, my lords.
Thank you very much for those kind words. The court is now adjourned. Have a very nice afternoon and God bless you.